Good afternoon, everyone, and welcome to our webinar on remote jury selection in King County Superior Court. This webinar is co-sponsored by the Court, the Washington Association for Justice, the Washington Defense Trial Lawyers, and the King County Bar Association. We thank these organizations for their help in presenting this topic to our practitioners. Presiding over remote jury selection today will be Judge Matt Williams, assisted by bailiff Shannon Raymond. Voir dire will be conducted by plaintiff's attorneys Alisa Brodkowitz of Schroeter Goldmark and Ann Rosato of Peterson, Wampold, Rosato, Feldman, and Muna, and defendant's attorneys Roy Umlauf and Carl Forsberg of Forsberg and Umlauf. I know I speak for all of my colleagues when I express our gratitude to these attorneys who have devoted many, many hours to help us roll out remote jury selection in our court through this webinar. Before we begin, I offer a few housekeeping details about our Zoom webinar format. Your video, audio, and chat functions have all been disabled. At any time during the webinar, you'll have the opportunity to submit your questions to today's presenters. To do so, just type your question into Q&A at the bottom of the control panel. As time allows, the presenters will address as many questions as they can during the presentation and during the Q&A session at the end. We will be recording this webinar and we'll share the link after the event. The Q&A is also being recorded, so please keep your remarks and questions focused on the presentation topics. In a moment, I'm going to turn off my video. To maximize your Zoom experience, you may want to hide non-video participants like me. To do that, hover your cursor over the non-video box, click the three dots in the upper right, and then click Hide. And now, I'd like to turn the Zoom speakers box over to our presiding judge, Jim Rogers, for a few remarks on the resumption of jury trials in our court during this pandemic. Judge Rogers would have liked very much to be here live today, but he's taking a much-deserved leave after many months of crisis management, so he's with us via recording. Let it roll.
Welcome to our jury selection in King County Superior Court. I want to thank all the people on the committee who made this happen, and I want to thank our participants today. Jury trials 2020, and what a year it has been. We resumed civil jury trials on August 3rd, and we've already started criminal jury trials and already conducted some Zoom voir dire. What's important to know about what's about to happen in the presentation you're to see is our health plans and a little bit of our introduction into our jury selection technology. So let me talk about those. When you come into the courthouse, or when you're remote and then come into the courthouse when jury selected, depending on how you begin your trial, be aware of a couple things. First of all, our courtrooms are reconfigured to be socially distanced. A lot of benches will be removed, there'll be chairs. If you're going to the Maytower Center, the spaces there are much, much larger. So it'll afford for a lot of social distancing. Second, everyone's got to wear a facial covering of some type, whether it's a mask, some other facial covering. We've learned from our many healthcare experts that we've consulted with, both from the Department of Health, King County, Department of Public Health, and also the University of Washington School of Public Health, that mask wearing does more than anything else to beat the coronavirus. The other thing you should know is that our HVAC systems are really improved. The air exchanges have been increased, and the filtration has been greatly improved. So that's very important for you to know. I'm sending a letter to every juror, the so-called code we call it, to talk a little bit about that and talk a little bit about the excusal policy that we're following during the coronavirus. There are no categorical excusals. You have to either present a letter from a medical provider or talk to a judge about what's happening. There are certain categories that will apply. The judge will speak to you about that. And finally, we anticipate all jurors to be selected through Zoom voir dire, through video voir dire, with the exception of some that either choose to come in person or don't have the technology. Now, technology here, I don't mean a computer, I mean simply the use of a cell phone, which is sufficient for appearance on Zoom. Some people also tell us and have historically told us they don't trust computers, they don't want their information on computers. Those people will also appear. So far, in our experience in criminal cases, that's been about 5% of people that either don't have the technology or wish to appear in person. they'll come in socially distanced. Most people prefer the voir dire by Zoom. It gives them greater access, allows them to stay at home or at work. They're being selected. So it's working quite well. I'm going to turn this presentation now over to the judges who are running it. And again, I want to thank you very much for attending this CLE, and we'll see you in court.
I'm Matt Williams. I'm one of your 53 Superior Court judges. Thanks for being here today. At the end of the movie Animal House, there's a wonderful scene with a very young Kevin Bacon running about in his ROTC unit saying, "All is well, be calm. All is well, be calm." Well, I'm here to tell you, be calm. All is well. Or as Judge Cahan, our Chief Presiding Civil Judge, said, you know, we're all going to be flexible through this process because our technologies and everything that we're doing is evolving. Today, we're going to show you the basic template of tasks. We're going to show you how this can evolve in your case in terms of being case specific. We're also going to talk about some of the differences between civil and criminal. And we're also going to talk about the modifications as it relates to the starting place, which is the jury summons. What you have on your screen right now is a basic roadmap. It's a template. It's a starting place. What the bailiff has to accomplish, which is significant, those are the tasks that are in blue. What the judge and the lawyers have to do, those are the ones that are in gold. And the things that are in gray, that's what jury services will need to be doing as we move forward. Because, of course, the work has to be done. We have to get the work done. We have to move forward the wheels of justice, but we also have to make sure that the lawyers, the parties, the public, and the court staff are as best protected and have the greatest possible access to participate in the process. So one of the things that you're going to see as we talk about this is that the timelines and the specific ways that these tasks are accomplished, they may change as our use of technology evolves. So we're going to talk about certain ways that we've developed, but even as we go through this presentation, you're going to see that even in the few weeks that we've been working on this, we've been developing new technologies and new ways of accomplishing things to be able to make things run as smooth as possible. The process is going to start. You'll notice that very first gray area under several weeks before trial. It starts with where jury services sends the new revised jury summons. And jury services now, instead of having everybody gather at the courthouse, they now will essentially assemble what are sort of mini pools, and they'll categorize those mini pools, not in person, but they'll categorize them internally, so that then those pools or those can be signed out to individual trial judges when the call and the need arises. Now, the next thing that happens, and this is the most significant thing in terms of a lot of the timing, is when the trial is either confirmed for trial or assigned for trial. And of course, that can work very differently based on the specific needs of the case. The criminal process may have one way of doing this, which is our standard way. The civil process may have a slightly different way. Traditionally, that assignment or that brokerage or confirmation occurs the Thursday before the actual trial date. And in most civil cases and certainly most criminal cases, that timeline will stay the same. And that's what you basically are seeing here. But in the cases that are not pre-assigned, it starts with the trial assignment. That's that thing that you see in day -4. The next thing that happens is that pool. Jury services will assemble this pool of jurors. It could be 90, it could be 60, it could be more than that, depending upon the specific needs of the case. And that list, which is an Excel spreadsheet, it gets transmitted to the bailiff. And the bailiff will, in turn, then make some modifications, and she'll upload that list or provide that list so that the lawyers and the judge have the ability to work with that. One of the things that is going to be happening is that almost every case will now have a pre-case questionnaire. There's some generic things that we're working on and developing a template, but also the counsel will have the ability, and you're going to see how that works, have the ability to craft specific questions so that we can identify specific hardships on that particular case, and we can do some of the challenges for cause before the jurors ever have to come to the courthouse. After that questionnaire has been finalized between the judge and the lawyers, then the bailiff will transmit it out to the e-jurors. Those are the jurors that have indicated that they have an email or that they're willing to participate via video. And the experience we've had so far is that's the majority of our jurors. But those jurors that don't want to appear video, they're not shut out of this process. Quite the opposite. The bailiff will make specific arrangements and will contact those individuals so that they know when to actually report for in-person voir dire. So after that process, things don't stop. Things are continuing to move forward, even in those cases where the assignment has taken place the Thursday before, motions and limitings take place, as well as other court-related matters, or the court and the lawyers can be working on other things. But part of what has to happen, there has to be time for the jurors to complete that questionnaire and return it back. And you can see on day 3 that, or day 2, the bailiff gets those questionnaires back, and we're working on the format. We're going to have a discussion about that, which then are transmitted so that the lawyers have a chance to see them. On day 3, you see what's called the pretrial conference hearing, or what we're now affectionately calling the hardship hearing. And this is a conference call, a Zoom hearing, it could be in person, where the judge and the lawyers meet and they go over the questionnaires that have been returned. And the purpose of that is to identify clear hardships and so that those jurors can simply be removed from the panel, as well as many of the questions will allow the judge and the lawyers to make preliminary determinations that this isn't the right case for that juror, and to have those challenges for cause made and reviewed and rule on there on the record, again, without the jurors ever having to come down to the courthouse. What will be left will be a panel, probably somewhere in the area of between 36 to 45. But remember, we've already removed most of the people with hardships, most of the people with causes, and then we begin the process of voir dire. And that's going to look and feel very different than what you're used to, because instead of the struck jury method, this will be much more intimate in the sense that you're going to have much smaller panels. The judge will begin with some preliminary instructions explaining how things will work. And one of those panels, or maybe more, will be those jurors that have said, yeah, I don't want to participate via video. I don't want my information on computer. I don't want to participate that way. And those individuals will actually be assigned a time to come down to the courthouse, to the courtroom, so that there can be, first, they can fill out their individual questionnaire, but then the lawyers can question them in a panel, which could be 6 or could be more, in a panel in person. Again, appropriately socially distanced and with appropriate personal protective equipment. But then the video portion of this will take place. And for that, there will again be dealing with smaller panels. Could be 6, could be more, could be less, depending upon the needs of your specific case. And what we're finding is that you actually get more time to question individual jurors than you did under the old struck method. Now, it does take a little bit longer. On the other hand, you're also not having to worry about personal protective gear, and what we're finding again is that the jurors tend to be more comfortable and certainly much more open, as you'll see when we do the demo. Which, by the way, I want to mention, the demo that you're going to watch was totally unscripted. It was done, it's a recording, but it was done without any other than kind of assigning roles. It was done entirely on the fly by the attorneys who were working very extemporaneously, and you'll see how effective it is. So after the panels have been interviewed, and during the panels, that's when for cause, while the jurors are still there, for cause challenges will be continued. Some of them were made at the initial hearing, that private hearing. Some of them are actually made during the panels, but that's where the lawyers will actually make their for cause. But the challenges, the peremptory challenges, are reserved, and that's that down under day 4 where you see exercise perempts in GR 37. That's a hearing outside the presence of the panels, outside the presence of the jurors. So as lawyers, you're going to have to take really good notes to remember who it is that you believe that you should be struck under for perempts, but also you're going to have to keep in mind those issues that might relate to GR 37 challenges. And then after those challenges, we will now have our panel, and those get assigned out. Can I have the next slide? Now, I've just shown you the standardized process. Now, some cases will have an early assignment or confirmation process, and that's what this looks like. And you'll notice day one here is way over on the left side of the screen, right side of the screen. And that's because what we've done, and in many civil cases and some criminal cases, the assignment can take place several, up to 10 days before. 2 Thursdays before is the plan that some cases might be able to be assigned out. And again, we can move much of that preparation, the preparation of the questionnaire, the sending of the questionnaire out to the jurors, even that pretrial hardship hearing can all be moved to the week before, allowing you to actually start your in-person and your video voir dire the actual start day of your trial. The key is to allow the bailiff to get those questionnaires out to the jurors, because the jurors need some time to be able to complete them. Now, the tasking is the same, but some things can be done early. This entire process, from start to finish, though, when you really think about it, it starts with that gray box at the very beginning. It's the jury summons. Next slide. And the jury summons is going to look very different, because the jury summons actually has some questions as well. And our jury services personnel have been empowered and authorized, when someone doesn't meet the qualifications, they're able to excuse them right up front. And so that's going to take place right up front. Next slide. The jury summons process now really has 3 steps, looking at this from the viewpoint of the juror. The first is we send out the summons with that short questionnaire. The jurors respond through the portal, through email, we're working on an online process, and any statutory excuses handled through the jury services. Then step 2 is that those jurors are put into the panels. They're assigned out to the trial judge. They're told not to report just yet, and then they get the case-specific questionnaire, which deals with health, hardship, other issues. And only in step 3 is when the trial judge actually tells them when to report, when to show up for trial. And it's important to note that in both step 2 and in step 3, the jurors are instructed to make sure that they watch both the standard jury orientation video, but also the video about implicit bias. So the full quote, going back to the civil process, the full quote, by the way, from Judge Cahan was this, quote, "Be flexible. We'll try to get you out early, but it will not always happen." So let me leave you with this thought, and that is, be calm. All is well. With that, let me turn you over to Shannon Raymond. She's going to walk you through what happens from the bailiff's perspective, starting with that when the bailiff gets that initial pool from the jurors.
Good afternoon, everybody. My goal today is simply to share some of the tasks that the lower bench, and particularly the bailiff, will be involved with when going through the voir dire process. And I would just encourage you to keep in mind what we've been doing since the end of February and into March. This process is in flux, as Judge Williams has said. And communication is going to be key for all of us as we, tinker with the process and improve it each time we go out on a new case. I also want to say that there are many facets of being a bailiff that are rewarding. I do want you to know that it is immensely rewarding to partner with counsel on any case that is moving towards trial and a case that goes out to trial. You should expect a partnership with the bailiff in the courtroom that you're assigned to, and understand that we appreciate that opportunity to partner up with you and learn from you. As Judge Williams mentioned, there are differences between a criminal case and a civil case, but in general, the process is going to be the same. The bailiff will be working with the jury department to communicate to them the number of potential jurors that we're hoping to have in our pool. And they the bailiff will also let the jury room know the case and case type and case number, any information that they need to know to work with the courtroom to get that pool of people ready for going out to trial. The bailiff will receive the list of potential jurors from the jury department, and then we will cut that list down so that we remove all of the personal identifying information, and we will send you a list that shows you the juror number, probably their badge number. We'll include their name, the city that they reside in, and this slide is showing you that the jury room reports a status for each juror. You can see where a juror has been summoned, and then once they confirm and return their juror questionnaire to the jury department, they will show up as confirmed. There are going to be some jurors that are excused by the jury department. They've got a limited amount of discretionary excusals that they can do. And so that status on this slide could show as excused, deferred, if they're deferred to a later time in the year, or they've been disqualified for any particular reason. There are going to be jurors that come to us without an email address, and if we have a phone number, the bailiff will be contacting those parties. We will do everything we can do to try and get every potential juror on that list made available to you so that you can question them and send, of course, your questionnaire to them. One thing that I think is going to be helpful for you to know is that we bailiffs are going to work with another courtroom, buddy courtroom perhaps, so that your jurors have a place where they can meet every morning, so they don't have to wait in the hallway, they don't have to wait outside. So that accompanying courtroom will be a meeting place, and we are making sure that we have at least 2, perhaps 3 jury rooms for them to take their breaks in or have lunch, or they can, do their restroom breaks in those rooms. So we've made extensive plans to socially distance our jurors at all times. Now that your counsel and judge have the jury list, I'm going to pass you over to Anne and Carl to discuss the juror questionnaire.
Thanks, Shannon.
Thanks very much.
Nice to see everybody. Well, here, everybody, see the list of all of your names today. Carl and I are going to talk with you about the summons information that you will have, the case-specific jury questionnaire, and then along with Judge Williams, we're going to demonstrate that piece in the timeline that is, we're calling the hardship hearing. I think what everyone has to accept now as reality as we do Zoom voir dire is that a case-specific jury questionnaire is imperative. It's a must. We learned through developing this process that a questionnaire like that is really the only way to effectively question jurors. You'll see that the Donahue method that we're all used to is a little more difficult in this setting. The key, you're going to have so much information from a case-specific jury questionnaire, frankly, probably more than you've ever had. The court will provide a template that has some background information, the COVID questions, and then the hardship questions. But then the lawyers are going to need to be working together very diligently, frankly, in probably the month before trial. You know what your case is about better than anyone. You're going to need to be working on and agreeing on a case-specific jury questionnaire that really gets at the issues that you want to know about. And if we could go to the next slide, you can see here on the timeline, although this is where the judges have determined that the questionnaire needs to be finalized by, like I said, you're going to need to be working on this really weeks in advance with your opposing counsel to come up with what it is you want this to look like. Go ahead, Carl.
I was going to say, if you can go to the next slide, you'll see what we're talking about there with the weeks ahead of time with the arrow right there. And this is, again, going to be different for criminal and civil. But in the civil cases, you're going to want to work with opposing counsel. And as Ann and I and Alisa and Roy worked on this, we saw kind of just what it would take to put this together. You're going to want to work with counsel. You're going to want to be thinking about the types of questions that you might put on a questionnaire like this long in advance while you're working up the case. Then when you're getting ready for trial, you're going to want to put these questions together. Work with opposing counsel, communicate with them, and then when you're ready, you can then go to the court. You're going to want to do this long before this time period here, which is the day one, and you're going to have it ready to go at that point. Go ahead, Ann, sorry.
Yeah, if we could get the next slide. As I mentioned, the court will have a template, sort of a generic template to at least get started from. That will have a place for your neutral statement to go. It will have a place for all the names of the witnesses to go so that jurors can identify if they recognize any of those names. The lawyer names, there will be specific questions about hardship. There will be questions about COVID risks that they can answer. But then you can see on the right, and the actual questionnaire we developed in our case was 8 pages. You can see 5 of them here. So you get a lot of information. Frankly, you get more information, I think, than you would normally get as you're heading into a trial and doing voir dire. But what you'll find, and we're going to give you some tips at the end, we actually just heard from Judge Williams today that the court is looking at a process that maybe is going to make this all electronic, so we're not even going to have 5 and 8 page questionnaires to deal with anymore. But you're going to have a lot of information, and you're going to have to get yourself organized heading into both the pretrial conference, the hardship hearing that we're going to demonstrate for you, and especially going into the questioning of the separate little mini panels.
Pretty much every case is going to have some form of pretrial conference. We're getting questions about, will we get the template? The short answer to that is yes, you will, as Judge Scott noted in the Q&A. But the reality is we are still evolving through our technologies. We have figured out a way, we're going to be testing it, that we can turn this all electronic. But the whole point of this is to make this as easy and make the pain process on either end of this as easy as possible, both for the jurors and for the bailiff. And the tasking for the bailiff as it relates to the management of this process is profound. So yes, you'll get that template. And the format of that template may be in the form of a Word document, maybe in the form of an MS Forms document, it may be in a different form. But just remember, be calm, all is well. We're going to be flexible, and we're going to adopt the technologies that work.
I think we can turn it back over to Shannon for her to explain again the bailiff role in this.
Absolutely. So once your counsel and have finalized that questionnaire, it's going to be time for the bailiff to send it off to the jurors. Each court is going to be different. We will all develop our own processes. So again, this is going to be another opportunity for us all to communicate with one another and make sure we understand the individual process that's occurring in that particular courtroom. For example, I am working on a case with my judge where we sent out the questionnaires accompanied by a short introductory letter from the judge. I took those 2 documents and I sent them individually to each juror because I wanted to make sure they understood what their juror number was. And I believe there has been a question already about that assigned juror number. We are clinging to that number system because it works. So you can count on that. When the questionnaire goes out, it will have a deadline associated with it, and we will be tracking those as they are out with the juror and as they come back. Those completed responses will include basic COVID information and with folks who are talking about potential hardships. The bailiff will collate those responses, and as Judge Williams mentioned, we are working on a process for distribution of those. And so Microsoft Forms may be the format that we ultimately use. It could be another solution. So that's in flux at this time. But we will make sure that those get distributed to council timely, and they will also be filed with the clerk. All right, I'm passing you back to Judge Williams and Carl and Ann to talk about the hardship hearing.
We thought we'd model one for you so you could get a sense as to what this looks like. This is in the mock case that we set up that you'll be seeing the actual voir dire of in a few minutes. Good afternoon, Council. Are we ready to proceed for our hardship pretrial conference on this case?
We are, Your Honor.
Yes, Your Honor. Defense is ready.
Okay. Well, Council, I know you've gone over each of the questionnaires. Let me start out just by noting a few of the jurors that appears to me may have hardships that we may want to go ahead and excuse them. Looking at juror number 2, looks like there we have an individual that has 2 kids at home, no child care options. Seems to me that would be someone we probably are going to want to excuse for hardship. Any objection?
Not from the plaintiff, Your Honor.
None from the defense, Your Honor. Thank you.
Turning to juror number 3, here we have someone who's 70 years old, also has requested a hardship simply because of their concern or because of their concern of being high risk for COVID and really doesn't want to risk their health for jury service. Once again, Counsel, I'd be inclined to grant that unless there's an objection.
Plaintiff agrees, Your Honor. I think this is a fairly high-risk juror, and he's clearly concerned, so we agree.
No objection, Your Honor.
Let's turn now to juror number 8. Also has requested a hardship and appears juror number 8 is, well, works for Amazon, apparently doesn't think that Amazon is not going to be able to function without her during the course of this trial. I'm not inclined to grant that particular that one unless counsel have strong feelings about this.
Your Honor, I agree that the hardship request doesn't make a lot of sense. Obviously, Amazon's a huge employer in the city, but to be frank, this was a juror where I was going to move in this hearing for cause. If you go further back in her questionnaire, this case is obviously against a nursing home related to the death of an elderly woman from COVID. She's a microbiologist. She apparently has done a lot of research, and she appears to be an expert on COVID versus the flu, believes they're the same, pretty much says that she could never, anyone who sues over COVID is, I think the quoted word there is lunatic. So I'm a little concerned that this isn't a juror that's going to be able to be fair from the beginning. So this is one where the plaintiff would move for cause to have this juror excused.
Mr. Forsberg?
Thank you, Your Honor. I think this is probably somebody we need to have come in, sit on one of the short panels and be able to examine her a little further. I'm not certain that it's not somebody that's just trying to get out of her jury obligation, frankly, to tell you the truth, with some of the hyperbole that we see here from her answers. So we would just ask that she come in and that we have the opportunity to examine her further.
And counsel, I agree. I think that, of course, most of our challenges for cause will take place, or many of our challenges for cause will take place during the actual panels. I think on this one, let's reserve and allow counsel to question her during the voir dire. Let's turn to juror number 9. Here, again, we have a request for a hardship, believes that she is a diabetic, believes that she's a smoker, says she has heart issues, appears to be at risk as part of the at-risk population. Counsel, I'd be inclined to grant this. Any objection, Ms. Rosato?
No, Your Honor.
Mr. Forsberg?
None, Your Honor. Thank you.
And now turning to juror number 12. Again, this is an individual that appears to be at risk, has asthma, is unable to wear a mask, really wants to participate though, so I don't have a hardship request here. under the circumstances, I'm inclined to allow her to come in, but counsel, I'd like your feedback on that.
Your Honor, I think she should be grouped into one of our little mini panels and question her in light of the fact that she clearly wants to serve.
Agreed, Your Honor. I'm wondering if we can't accommodate in some other fashion, perhaps something like this.
Yeah, we do have a limited number of facial shields available, and Mr. Forsberg, I was going to propose that I actually asked my bailiff to specifically reach out to her and find out what she might need in order to be able to come in, so that we can have bring her in and she can have participate in the process.
That'd be great.
So we'll make a note on that, and I'll ask my bailiff to do that. Those are all the ones that I had as it related to hardship. Ms. Rosato, did you have any related to cause?
Well, we discussed juror number 8, Your Honor, but the only one I'd like to draw your attention to, I don't have a cause challenge at this time, but juror number 1 is the young UW student. He appears to have been a former athlete and coached by defense counsel Mr. Umlauf for several years. So I just want to alert the court to that and make sure we pay close attention to it during his questioning during his individual session.
Okay. Mr. Forsberg?
Thank you. I'd like us to look at, if we could all look at juror number 4, Your Honor. I think if you look at her, she does say that she's familiar with the defendant here. She says that her mother-in-law lived at the residence. And I'm wondering if, given those circumstances, not wanting to try a case within a case here with a potential juror, if there wouldn't be perhaps another trial that she could sit on and might be better for all concerned, Your Honor.
Ms. Rosato?
Your Honor, I've reviewed her questionnaire, and plaintiff is not opposed to her being excused for cause.
Okay, I'll accept the challenge for cause. We'll strike her from this panel. Okay, thank you, counsel.
Thank you, Your Honor.
For those of you that are,
Thank you, Your Honor.
For those of you that are participating in the webinar, I want you to note that the examples we show you, they were all handwritten. That should tell you how fast our technologies are evolving, because we know that when the jurors return those, or we firmly believe the jurors may be returning handwritten questionnaires, but it's highly unlikely. Well, certainly they'll be typed in some form or fashion, whether it's in response to essentially what would amount to an online survey that is coming back with them typing in responses, or even if it's just a Word or an Adobe document that's being sent back and forth. So that should tell you how fast just in the course of developing the seminar, our technologies and our flexibility. Well, be calm, all is well. Counsel?
If we could go to that next slide there, as we prepared these questionnaires and got ready for this CLE, we were dealing with paper questionnaires. And I think that's more traditional for those of us that have tried cases with questionnaires. As you know, there's this scramble over lunch to get copies from the bailiff, and then you have to collate all this information over lunch and get organized. And so this slide you see here is an example of going into either the hardship hearing or your voir dire. You're going to want to be organized. What Judge Williams is describing is, I think, actually going to make it a lot easier. The perhaps Excel format you're going to get is going to make it even easier to be organized. But you're going to want to know going into this hearing that Carl and I just demonstrated who you want to talk about, why you want to talk about them, and very specifically what the rationale is.
This particular chart, Anne put this together and said this is something she uses. We use something very similar to this. You're going to want to put this together, and you're going to want to put it out far enough for those, when you think of all your preempts and the potential challenges, you're going to want to have the information out far enough for that number of jurors. And this is something that if you start it now, get it ready as soon as you get the information, you'll be able to use it for the cause, for the hardship, and then also for the voir dire itself. So it is time well spent. As soon as you get those questionnaires back, you and your trial team start going through and putting something like this together at that point.
I really want to emphasize something that Anne said a few minutes ago, and that's in terms of sort of this evolution from, well, the way things used to be to the essential realities we deal with now. You know, there are some things that maybe just be a bridge too far, and having to deal with an Excel spreadsheet when you're used to dealing with individual questionnaires. Well, look, we're sensitive to that. Those of us that have worked in both formats, frankly, we find the Excel format, which we're working on being able to get that for you. It's actually easier. It allows you to assemble information easier. But the reality is you may well need and feel that you really need to have those individual questionnaires. And so those are issues to make sure that you make clear to your judge and your bailiff, because we're working hard to make sure that we have the option to give you what you need to be able to try your case in the best way possible. Certainly getting those individual responses or the responses back on an individual juror's basis, we recognize that's the format you're used to, and well, you know, some things may be a bridge too far. Make sure you talk about that with your trial judge and with your bailiff. And did you have, and I think we are ready to start the next, and I think we're going to turn this over to Shannon so that she can talk about what happens after, if we can go back one slide, there we go. Shannon is going to talk about what happens after we conclude that hardship meeting, which is now what we have is we have this pared down list, and she's going to explain what she does with it. You're going to, again, you're going to see this is a heavy workload on the bailiffs. Shannon?
Very good. That hardship hearing has taken place, and the bailiff will have a list of jurors remaining in the pool, and it will be the bailiff's job to contact each and every juror and let them know whether they have been scheduled for a Zoom hearing, likely the next day. Those hearings, if they do participate in a Zoom hearing, will be scheduled to last, they'll probably be scheduled 45 minutes apart, depending upon the number of jurors that the court has decided to take into a group. The courtroom technology will be set up and be ready to go for you. There will be some jurors who cannot participate via Zoom, and they will be invited to come in person, and I would expect that they might be sprinkled throughout the day, maybe an in-person pool in the morning and an in-person pool in the afternoon. We will be coordinating, we the bailiffs will be coordinating, working with our buddy courtroom to make sure that there is a break area and a waiting area for anybody who is here in person. So you can count on the fact that that will be taken care of. I would be remiss if I did not let you know, and Judge Williams has alluded to this, that for the bailiffs, this is a very different format for our workload, and we are anticipating getting numerous questions from jurors. I've already started getting some from mine. They are eager to know when they're going to be scheduled. Will they be excused? Can they make daycare arrangements? You know, the list goes on and on. So I would ask that you keep that in mind as you're communicating with the bailiffs in the different courtrooms. We are adapting, and we want to be here for you to help you in any way possible, but we might be climbing up our learning curve and dealing with sort of an increased volume of work. We will be available to you on the day of Zoom voir dire. One of the things we do is get everybody, make sure they are on the call, make sure they are able to access their technology properly, and we will rename those jurors so that when they appear on the screen for counsel, they will say Juror 27, Juror 29, Juror 33. You will know exactly who you are speaking with at all times. Thank you for your time, and on behalf of the lower bench, if we can help you in any way, just let us know.
So what winds up happening after the bailiff has basically told people when to report, whether they're live or whether they're Zoom, is, if you'll go to the next slide, what you'll see is, of course, we're going to have that in-person panel. Now, we're not going to show you the in-person panel because, well, most of you have already done that. So that's not part of what we're going to be demoing today. But what we are going to demo today is the Zoom panel. And one of the things that I want to emphasize about what you're about to see is we truncated the jury instructions. We really pared it down so that you get the flavor rather than necessarily the mechanics. And the lawyers are going to talk after the fact about the difference of their experience in terms of the types of questions they asked and how they interacted with the jurors. The instructions at the start have been truncated. There's a relatively complete, we're still working on it, but it's a very complete set of rules that starts at the beginning in terms of what the jurors are required to do, what they can't do, screens on, no recording, things like that. We also want you to know that when we recorded this, we were unable to show you the actual juror numbers, but they were there. So you can see juror number 1, juror number 10, juror number 11, and so it's there on the bottom of the screen. And with that, I'm going to ask Roy, let's go to voir dire.
Okay, members of the jury, if you could turn on your cameras so that we can see you. Thank you. And in a few moments, I'm going to ask you to unmute so that we can begin this process that's called voir dire. Let me tell you about this case. This is a civil case by the estate of Evelyn Martin against End of Days Nursing Home, LLC. The plaintiff's attorney is Alisa Brodkowitz. The defendant's attorney is Forsberg Umlauf. The claims in this case arise from the death of Evelyn Martin from COVID-19 on May 10, 2020. Ms. Martin was a resident at End of Days Nursing Home in Seattle, Washington. The claim is brought on behalf of the estate of Ms. Martin by her adult children, Aaron Martin and Sandra Martin. Plaintiffs claim that End of Days Nursing Home was at fault for the death of Ms. Martin. Their claims include negligent failure to quarantine sick residents, failure to test sick residents, failure to provide proper medical care, and violation of the Abuse of Vulnerable Adults Act. End of Days denies that they're at fault and claim they did everything they could to care for their sick residents. They contend that they are not to blame for lack of COVID-19 tests. They claim that they did not provide reasonable and necessary care to Ms. Martin and the other residents and did the best they could given the size of their facility and the number of staff that are employed there. Now, you've already been asked a series of questions, and you've answered a series of questions as part of your questionnaires. To follow up, the lawyers and I are going to ask you some additional questions about your ability to serve, your background, and about your life experiences. For those of you that are watching the webinar, at this point, there is a long section of WPI 1.01 that deals with implicit bias and this actual swearing in of the panel. We're going to bypass that and move forward into the hardship questions that the judge might ask in your trial. So let's, first off, let's test to make sure everybody's listening. I will need all the jurors. I need you to wave your hands so that I can see you waving your hands. Okay, 1, 10, 12, excellent. Now, serving on this jury is going to require that you physically report to the courthouse for each day of trial. Is there anyone here who would be unable or unwilling to do that? Raise your hands, wave your hands. Juror number 7, you're raising your hand. Juror number 7, what's the reason why you'd be unwilling to report to the courthouse?
Yeah, Judge, with all due respect, I was just allowed to open up my business again.
I'm sorry, sir, I can't hear you. You're going to have to speak a little louder.
Oh, sorry. I was just allowed to open up my business again, and I mean, I only got 2 other managers that are there, and they need me to run the business. So I think it is a hardship.
Okay, what kind of business are you in, sir?
I run a gym. It's called 35 Fitness.
And what are your hours of operation?
They were shortened a little bit due to COVID, and we're emphasizing classes now, but it's basically 6 a.m. to 6 p.m.
And you said that there are 2 other guys that you're in this business with, correct?
Yeah, one guy's a lady, but yeah.
Okay, 2 other people that you're in the business with. And
right.
The estimated length of this trial is about a week and a half. Would one of them be able to cover for you for that period of time?
I mean, honestly, yeah, I know him big time, but it's possible.
Okay. Does anyone have a chronic health condition such as heart disease, lung disease, diabetes, or a weakened immune system? Raise your hand. Okay, no one's raised their hand. Is there anyone experiencing any one of these symptoms? And if you are, I need you to raise your hand. Fever or chills, cough, loss of taste or smell, shortness of breath, muscle or body aches. If you're experiencing any of those, wave your hand. Okay, juror number 1, you reached up and I think you pulled your earbud out. I don't think you're raising your hand, were you? Okay. Counsel, Ms. Brodkowitz, you have 12 minutes.
Thank you very much, Your Honor, and thank you to all of the jurors here who have made themselves available during a pandemic. So I'd like to start by telling you that I represent the Martins. Sandra and Aaron are the kids of Evelyn Martin, and she died in end of days nursing home, as you've heard from Judge Williams. Judge Williams also read you the neutral statement of the facts or the case, which tells you a little bit about why the lawsuit has been brought, that she died of COVID in the nursing home, and our allegations that she should not have contracted it. So that brings me to my first question, and I'd ask that if you are able to respond or want to respond, to just raise your hand, and then I'll say your number and you can unmute yourself and tell me your thoughts. So my first question is this. President Trump has been supporting legislation recently that would provide immunity to any business that opens during COVID, meaning that you can't sue a business if it opens during COVID and someone contracts COVID there. Is there anybody on the panel who thinks that this is a good idea or would be a good law? So does everybody raise your hand if you think that would be a bad law to create immunity for businesses if you got COVID, you contracted COVID at the place of business? Okay, so that's juror 11, juror 5, juror 1 thinks that we should not pass that law. So I haven't heard from juror number 10. What are your thoughts on this?
I don't really have any.
Okay, understandable. What about juror number 7?
Yeah, I mean, I figured the justice system should decide. The rules shouldn't change. But personally, I mean, I worry about opening my gym to customers. So I'm not going to support it, but I'm not going to say that it's bad either, some sort of in the middle.
Okay, got it. And of course, that is not the law now. And may never become the law. In this case, is proceeding under the current laws of Washington, as we must follow in this courtroom, in Judge Williams' courtroom, which is that there is liability for negligence and other acts. So let me get to my next question. In 2016, sportscaster Erin Andrews was awarded $55 million after someone looked at her, the peeping Tom, at a Nashville Marriott hotel. She was videoed nude, and that went to the internet, and the jury decided she should get $55 million. Is there anybody here who has a problem with that or thinks that that's too much? Juror 10, can you explain why you don't have a problem with such an award, $55 million?
Do you say juror 10?
Yes, I did.
I mean, I don't really know much about the case, so I can't really say one way or the other, whether it's a lot or a little.
How about juror number 5? Can you tell me your thoughts on a $55 million award just for seeing someone videoing them nude?
I would also need to know a little bit more about the facts of the case, but I do think that that is an egregious kind of invasion of someone's privacy to be filmed nude. So I would agree to award them some type of compensation. I don't know if $55 million is a little high, though.
Thank you very much. How about you, juror number 7? What are your thoughts on that?
Yeah, I agree with juror number 5. You know, it's just completely out of bounds conduct. And she's a public figure that probably had significant financial impact. So I wasn't there at the trial, but I guess the way it was presented, it probably made sense to the jury.
How about juror number 11? What do you think about that?
I agree with number 7. I mean, I know Erin Andrews is a public figure. I know she doesn't need the money. So I'm sure it was really just a statement to the Marriott and the community about that sort of egregious conduct, which is really disgusting.
Is there anyone here, and thank you, juror 11, is there anyone here who would have a hard time awarding damages to an elderly person who dies of COVID? No? Okay. I'm going to ask some specific questions here. Juror number 1, I read your questionnaire and I understand that you know Mr. Umlauf here, who represents End of Days Nursing Home. Is that right, juror number 1?
Yeah, that is correct.
Can you tell us in what capacity you know him?
He was my high school club soccer coach.
What position did you play on that team?
I played defense.
And so he was the coach and you were on the team, but would you have considered yourself all one team, so to speak?
Yeah, I would say we were all one team.
And were you under the direction of Mr. Umlauf? He told you what to do and set certain rules for you and you followed them?
Yeah, for the most part.
And you must have grown very loyal to Mr. Umlauf in the process.
Yeah, I was pretty loyal, yeah.
Did you look to him as sort of a father figure?
In some ways.
Okay, thank you for that. I guess my last question is if Mr. Umlauf went and coached for the other team in one of your games, would that pose a problem for you?
I would still play the same.
You wouldn't play any differently, are you sure?
Yeah, I wouldn't give up any goals or anything.
Okay, thank you for that. Juror number 10, see how I am for time here. I'm going to ask you.
2 minutes, Ms. Brodkowitz.
Thank you. Juror number 10, you said you saw reference to this incident on the news. Can you tell us a little bit about that?
I think I just saw a headline somewhere.
And what did the headline say?
I don't remember.
How do you know it was End of Days nursing home?
I'm not sure. Like, I think maybe it was, but can't say for sure.
Thank you. Okay, juror number 5. You are a lawyer, is that right?
Yes, that's correct.
And what kind of law do you practice?
I used to do defense and now I'm doing plaintiff's personal injury.
Why did you choose? Did you find it was much more satisfying to represent victims?
No, I just decided to branch out on my own and there was a lucrative opportunity representing plaintiffs.
What kind of plaintiffs? Any in particular?
No, I do a lot of small motor vehicle accident cases.
If you were presented with a case involving someone who was elderly and died of COVID at a nursing home, would you be interested in representing that person?
That's a little bit outside of my expertise, so I would probably not at this time.
Do you think that by virtue of your background, you could be helpful in this case?
I'm not sure I understand what you mean.
Do you think that the fact that you are a lawyer would help you explain things to other jurors?
Perhaps.
Okay, thank you. Juror number 11, it says here you are a barista, is that right?
That is right.
Are you back at work now, or are you still, is your business shut down?
We just started opening for to-go orders, so I haven't gone back to work full time. It's still kind of up in the air, so yeah.
Well, that is the end of my time with all of you. Thank you for your candid answers, and I'll pass the floor to Mr. Umlauf for his questions.
Mr. Umlauf, you have 12 minutes.
Thank you, Your Honor. Thank you on behalf of my clients for being here today and for filling out the questionnaires. The questionnaires are very helpful to us and give us a lot of detailed information. One of the other jurors in their materials said that they think that nursing homes are more concerned with profits over the safety of their patients. Is there anybody on this panel, raise your hand if you believe that nursing homes are more concerned with profits over the safety of their patients? Anyone believe that? Juror number 11. And why do you think that?
Well, I wouldn't say all of them, but, you know, I think some are bigger corporations or entities, and I know how big companies work, and it's all about the bottom line. So it would just depend on the facility. I'm not familiar with the one in this lawsuit.
Okay. And how long have you felt that big companies just are kind of worried about the bottom line?
I mean, for as long as I can remember, you know, I'm kind of the little guy for the little gal, so that's
okay.
how I view things.
And you, to the extent if my client is a part of a bigger company, do you think you'd have trouble putting that aside?
I mean, I could put the evidence or whatever is brought before me, and, you know, I'm not gonna just be completely biased, but it would just depend.
But I mean, that's a long-seated belief that you've had for many years, that you think big companies are more worried about profits than safety. Is that fair?
If it shows that that's the case here.
Right. But I mean, would you be able to set that aside in this case? I mean, it's not going to go away in the next 6 days, that belief that you have, is it?
Yes, but I can listen to the evidence and be fair, so I could do that.
Okay. All right. And I saw that you also had some experience as or you checked the box, teaching box. What was that about? Maybe somebody in your family?
Yeah, just family, not myself. Some teaching, yes.
Okay. Now, you also checked a box that there was something you wanted to take outside the presence of the jury. Is that right?
I did check that box, yes.
Okay. And Your Honor, I think we can maybe address that at a later point. Thank you.
We will, and we will schedule a time in probably about 3 hours for us to have an additional session to talk about this.
Okay. Juror number 1, you were asked about when I coached you in soccer. Did you always agree with me, my coaching decisions?
Not always.
I mean, you have your own mind, and in this case, you listen to the evidence and make up your own mind, correct?
Yeah.
I mean, you wouldn't just because I presented it wouldn't mean that you just necessarily go with what I say. Is that fair?
Yeah, that's fair.
Okay. So, juror number 5, you check the box that maybe someone that is related to you or close to you is in healthcare or mental health. Can you tell me about that?
My mom was a labor and delivery nurse.
Okay. And is she still?
No, she's not.
Okay. I mean, do you have anybody that's involved in labor and delivery right now?
No.
I mean, anybody involved in healthcare right now?
No.
Okay. Juror number 7, again, I'm kind of skipping around here. You're a gym owner, but I also saw that your spouse is an ER nurse, and that's very admirable. And she's involved right now with COVID patients. Is that correct?
Yeah, I mean, they got to triage them out, but they're presenting to the emergency room like many other patients.
Okay, and how is that going? How does she kind of protect herself from? I mean, at work in terms of protecting you, does she take special precautions?
I mean, it's at least a couple layers. You've seen the big plastic face shields and the face masks. She's wearing them. You know, she comes with the line across her nose from the tension of having that on all day. But yeah, it's tense. What can I tell you? She doesn't know if she's subject to exposure.
And has she had COVID experiences herself?
You know, knock on wood, nobody personally in my family's had it.
Sure. And at your gym, how are you dealing with the COVID situation?
Well, like I said, we've got emphasis on classes. We're keeping a close eye on the governor's mandates, because we're allowed to have them outside our gym now. And if people come into the desk, you know, we're all, you know, no mask, no service, and trying to make it work.
So if someone got COVID at your gym, would you think that you automatically are responsible to anybody that gets it?
There's nothing automatic. No.
No, but I mean, do you think that that would be appropriate, that anybody that gets COVID at a facility, that now all of a sudden the gym, just because that's where they got it, that the gym should be responsible?
Like I said, I don't think it's automatic. I mean, if the gym did something that was, you know, below what's expected of the gym, that's one situation that, yeah, there could be responsibility.
But if the gym did everything they could to prevent it and it just happened, do you think the gym should be responsible?
Yeah, I mean, everything they could. If they're doing what the governor says and the health department says they're supposed to do, and they've got a plan, that's the key.
Okay. Now, has everybody heard about, and raise your hand if you have, has everybody heard about that there was a Kirkland nursing home where they had a COVID outbreak? Has everybody heard about that, and that some people died in connection with that? Now, does anybody believe that automatically the Kirkland nursing home should be legally responsible to anyone that gets COVID at their facility? Anybody believe just automatically they should be responsible just because they got it there? Okay, good. So juror number 7, have you actually had, it looked like there was maybe some lawsuits in your, or that you've been a party to a lawsuit, is that right? I thought you had checked that, juror number 7. It says you had checked, been a party in a lawsuit. What was that about?
It was just a dispute with an old business partner who no longer is one of my business partners.
Okay. And were you the plaintiff or the defendant?
I was defendant.
Okay. How did you feel about being sued?
It was a major distraction. I didn't like it one little bit.
Okay. And you also checked the box, had COVID-19. Did you personally have it?
No, I thought it was just if we knew anybody that had it.
Okay. All right. And
sorry if I read that wrong.
No. And someone close to you?
No, just an acquaintance.
Okay. And in terms of someone being treated for COVID, or you knew someone, that would be your wife treating somebody that had COVID. Is that right?
Exactly.
Okay. Is there anything that you think, knowing what you know a little bit about the case now, is there anything that you think that we should know about you that that we haven't talked about? That if you were in my shoes, you know, kind of asking people about this, is there anything that you think that we should know about you before we let you on the jury?
Nothing's coming to mind.
Okay. Thank you. And juror number 10, tell me a little bit about what you do as I understand it, you're a game developer. Juror number 10.
Actually, I work for quicksip.com. So they do special betting type of products, but they sell it online.
Okay. And have you been working remotely, or have you been going in?
Just work from home.
And tell me a little bit about how COVID has impacted your life or lifestyle.
I mean, not really. I was mostly working remotely to begin with, so it's about the same.
It says you've testified in a court before. What can you tell us a little bit about that?
My dad was, a liquor store owner, and he got sued over, so I testified in that.
And how did he feel about getting sued as a liquor store owner?
I mean, it was a fake claim. They're just trying to screw us. So that's about how we felt about it.
Okay. Now, have you or any family member checked a box connected with the court or judicial branch of the government? Tell me about that.
I have a friend who works for the court. He's like a bailiff for security, something like that.
Okay. And you also checked the box that you'd heard of our firm, Forsberg Umlauf. Tell me a little bit about that. How do you know of us?
I mean, I'm not sure if I do. I thought I might have heard about it, so I figured I'd be safe and check it.
Okay, but you don't recognize me or Mr. Forsberg?
No, not at all.
Okay.
Counsel, I'm afraid your time is up.
Perfect. I'm right at the end. Thank you, Your Honor.
Ladies and gentlemen, we're going to excuse you now. What will happen is that my bailiff will contact you via email or will call you and tell you what the next step in this process is. We want to thank you for your participation today, and we want to thank you for not only your time, but please stay safe, stay healthy. And with that, we are adjourned.
So I'm going to leap in here so that we can go to the next slide, but also so that we can have a discussion with Roy and Alisa real quick about their process and how they found this to be different than the struck method, which is what has recently become more common, what many of us are more used to than this older panel method or the strike and replace method. I did want to note two things for everyone. You may have noticed that there was a lot of start and stop. It was kind of glitchy. That was the video. The actual Zoom voir dire that we did, and Roy and Alisa can confirm this, as I think the other participants, was very smooth. It had the juror numbers right down at the bottom. It was really easy to keep track of who was paying attention, and very easy to keep track of kind of what was going on. I also wanted to note that at the very beginning, you notice I asked the COVID-19 questions, and I have to tell you that now I wouldn't do it that way. I would really want to approach that much more delicately without requiring folks, individuals, to answer those questions in front of the other jurors. And so we'd probably do that in a more private setting. And of course, during any voir dire, there's going to be those questions where the juror wants to talk about something privately. And there's a whole bunch of different options, different ways that we can do that. And you've got 3 of them up on the list. And one is simply to take that individual juror into a breakout room. You can put all the other jurors in a breakout room, or we can just, as you saw us do, set up a private session. Anyway, let me turn this over to Roy and Alisa. In terms of this experience, being able to look at the jurors, how you ask questions, Alisa, let's start with you. What was your sense? What was your feeling in terms of how you had to change how you approached this?
I felt like when I asked questions of everyone at once, and there are going to be 6 jurors at once, so just as a practical note, you'll have to sort of introduce yourself 6 times and kind of go through it. But I felt like when I asked just an open general question, people were a little bit more reserved about kind of popping up and giving an answer. So it sort of helped me. I started doing more general questions, but then call in individual people. So I also noticed that I actually see a lot more of the face using the Zoom method here than in the courtroom. And it made me think to, what is that trial going to look like? And how much of my trial is going to be remote testimony anyway? And I made me think, well, if we're all going to be in masks, maybe I would try to work something out with opposing counsel and ask them to do everything remotely. And I understand that would be maybe different, and you'd have to get the judge's consent, but just something to think about.
Roy, how about you? What was your experience in terms of how you had to formulate questions, your ability to interact with the jurors?
I think the jurors were a lot more relaxed being at home or wherever they were. So I think that was helpful. My tips to kind of how to do this is I think you need to really be organized, prepared, and practice. I would typically Google the jurors as part of my preparation so I could get more information. Second point is I think the questionnaire is really key. There's a lot of information, and there's some of the handouts, but The time goes pretty quick, but I think it's enough time, particularly with the questionnaire. So, look at those handouts, you can kind of see. So I think you get a lot of information. And then I guess the last point would be have somebody help with the process. So this is a screenshot of what you'll see. You'll see the jurors' names or numbers. It'll just be their numbers. You'll also, as you can see on this slide, there's a person there listed, Kristen. That would be someone potentially my office, or you could have your client also assist, because I think having someone while you're doing the questioning take notes and help is really important. I think another alternative you can do is, this is an example of me being on the Zoom, but I could also have somebody in a conference room appropriately socially distanced, and you could then have them kind of taking notes, getting feedback. So I think the process is, you really just need to have some assistance, I think, to help with it. But I agree with Alisa that you can see a lot more up close than you can necessarily in the jury room, where you're actually further apart.
I do want to really emphasize for those of you that are watching that what Roy is showing you, that screenshot, that's of course of a mock juror. Do not make a screenshot without first getting your judge's approval. And many of us have pretrial orders that specifically say no screenshots, no recordings, no one can make a private recording of this without the court's approval. We got some questions during the chat that related to how do we make sure the jurors are paying attention? How do we make sure there's no distraction? And the reality is that's part of those initial rules that we talked about that we had to cut for time purposes. One of the other interesting interactions with, I believe it was juror number 7, we actually talked about the fact that you could see so much of what was going on behind him in terms of possibly that revealing private information. And I actually made an inquiry of him to make sure, are you comfortable with that before we proceed? In other words, moving people to having them move to a background that's less distracting. We also discourage jurors from using virtual backgrounds because it eats up bandwidth, and that can cause glitchiness. Roy, Lisa, would it be fair to say that you found this process different than the struck jury method, but that were you able to get done what you needed to get done to find out about whether or not you wanted somebody on your jury?
Objection, that's a leading question, Your Honor. Just kidding. Yes, I would say absolutely. You were able to get done what you needed to get done and see the faces, and you can see the jurors react to each other. You can see the judge react to the jurors. So I liked it that way. One thing we didn't show that will be a reality is that Roy or I would actually have our plaintiff or defending client also participating remotely as well, so the jurors could see their face, they could see the juror's face, and you could choose whether to have them on video or not. What do you think, Roy?
No, I think it's a different process, and I think you just got to get used to it. I think the added benefit is questionnaire. I mean, I've been trying to use questionnaires in almost every case I do, but now to have it as part of the process, I think is fantastic. And I think using the questionnaire is really helpful, but you got to be organized, just like any voir dire. And I think the nice thing is you have that questionnaire to fall back on, because there may be things that you can find out that aren't in the questionnaire. And the great thing is you get to talk to each juror for 2 minutes, or actually most of the time it'll be 4 minutes, because each side will be talking to most of the jurors. So I think, yeah, definitely you can get what you need to get your job done.
And is it fair to say, though, that this is a different experience than standing in front of a group and essentially, lecturing or talking to the group? This is a much more intimate relationship. You're able to develop much more of a connection with your jurors. Is that fair?
Yes, and it is definitely unique to be able to see into each juror's home. I didn't find myself feeling comfortable enough to ask them about things in their real background, but I feel like it helped sort of paint the picture of who and what they were about.
Well, and I think you can see some of their body language and you can see maybe the jurors reacting, and it's a little easier just all on one screen to be able to see them whereas sometimes you can't do that in a courtroom where there maybe is a juror, in a different part of the courtroom. So that the one thing about it is a little bit more intimate because they're all on one screen, and that's very helpful.
And Judge Williams, I know you did say, not to do a screenshot without the consent of everybody, but I do see the screenshot as being having a real potential use, especially for Batson or GR37. So with the consent, we have a different rule in federal court and state court. It's the judge's discretion. But with the judge's consent, I think that can play an important role in your GR37 hearing.
And certainly one of the things that, as we transition to GR37 and go into the next slide, one of the things to remember is that, yeah, you're going to have to keep track of all those jurors. Some judges feel very strongly about those screenshots and about the privacy interests reflected. Others have different feelings. The key issue here is don't just take a screenshot. Have that conversation with your judge, preferably before you begin your voir dire process. And in some of our cases, I know that screenshots actually, with the consent of the court and the jurors, the court actually took those screenshots. So you could see the juror numbers and you could see that. Now, is that going to happen in every case? Don't count on that. This is very much about the arguments that are made in front of the judge and the way that particular judge views and the jurors view those privacy interests. But let's talk about what's going to happen in terms of peremptory challenges. Now, especially here in King County, we're very used to, you got the entire panel there, you finished your voir dire, you stand up and you say, Your Honor, we thank and excuse juror number 11. And by the way, you may have noticed in the video, juror number 11 was spending a lot of time staring off above the screen. We're not really quite sure what at. But that's our standard process. You stand up and you say that, and the jury's all there. Well, that doesn't happen here. Why? The jurors, these panels, they've gone away. This is actually a more traditional way of handling peremptory challenges. And so now we move into this next hearing, which is the exercise of the perempts and the GR37. And Anne, Carl, do you want to talk about how you would handle that process?
So I actually have been thinking a lot about this, and I don't think this would be all that different than how I currently handle it. And if we go to the next slide, you can sort of see some different ideas for organizing. I actually already do something really similar to this. I use a large kind of file folder manila thing, and I have Post-its, one Post-it for every juror. And as I'm getting information and as they're getting excused for cause, I'm just moving Post-its around that. So I think I would use, it's essentially the same as the jury chart here. You're just going to be keeping track right there at your desk, maybe with a helper from your office, and organizing yourself and rearranging the jurors as you go, so you know who's in the box and who's been excused. I guess I would just add that, I definitely, as Alisa's co-counsel, got enough information in that round of voir dire to know, and she and I discussed, we probably would exercise a peremptory on juror number 1. I mean, he said during Alisa's questioning, she got some good questions with him, but then it was fascinating to watch Roy come back and through leading questions get him to say, oh no, I'll do whatever you say, basically, through the leading question. So we sort of knew we would get rid of juror number 1, and using one of these methods, we would be organized to know he's going to go, and then you're going to move the next juror up. It's going to all be on paper, though. It'll be different.
We do it the same way. Actually, we used to work with Ann, so we do the Post-its as well. We move them around when we're in court with the information on them. Here, I would do it similar to what we have up here. You're going to want to take much better notes. If you're not going to get the screenshots, I'm a very visual person, and that helps me remember different answers from the jurors. So you've got to take much better notes given these circumstances. I believe you're going to want somebody to help you, like that picture that you had with Kristen and Roy. One of the questions was, can you have other people there? Yeah, you'd be able to have other people there. You'd want to talk to the judge about it, make sure who they are, and they will be identified by a name at least. You wouldn't want them on screen. And I would say you're only going to have 6 at a time. So for me, It's much more specific. It's going to be much easier. I don't have to look behind me if you've got some people in the box and some people out in the galley. So for me, it's going to be a little easier to do this. And you saw how Roy got very specific with some of the questions that he got from the questionnaire, some of their answers, and he was able to get very good information. For us, we likely would have tried to remove 5 and 11, 5 the attorney, and 11 the person, the barista. We had looked at those. Now, if Roy and I weren't in the same place, and we wouldn't be because of social distancing, we would either have to go offline, talk on the phone, or do something else to talk about if we were co-counseling this. And that's something you'd want to talk about beforehand so that you weren't trying to figure it out on the fly while you're trying to go through the preempts.
The only other thing I'll add is I've been thinking about this, you know, usually we're all in trial and we have the jury box there and someone excuses juror number 2 and the judge says, okay, juror number 15, please replace that seat, and you have this visual. We're obviously not going to have that, but I still think after each peremptory, counsel and the judge could have a quick, all right, let's everyone confirm now who's in the box quickly. Okay, next person go, exercise your peremptory, have that same discussion again, just to make sure everyone's on the same page.
Roy, could you go back to the PowerPoint, that last slide real quick? And if you look at the slide on the right, the chart on the right, that actually is a way that you can actually move forward. The blue little thing there shows how many, that's 14 jurors there. And every time somebody gets struck, that little box just moves one more over. And that can help you keep track. Changing the subject a little bit, I mean, obviously when we have all the jurors in the same place at the same time, Batson and GR 37 challenges and the argument on them becomes problematic. And could you and Carl talk about how you would keep track of information that was necessary for Batson and GR 37 issues?
Carl, what are your thoughts on that?
Well, again, for me, it's going to go back to the notes and it's going to go back to the examination. And that's why I say you're going to really have to take much better notes and you're going to want to think about that ahead of time. And as you get the information, you're going to want to put down shorthand notes so that you and your co-counsel, if you're together, are both on the same page with that. So it comes down to those notes and that questionnaire. And then when you see the folks, you want to start jotting down notes right away when you see them up on the screen. You've only got 6, so you can take pretty quick notes.
Yeah, I agree. I still see this as being fairly similar to what I do, which is taking little notes on the Post-it so that I know that's the one juror I'm going to talk about, and maybe having a few quotes of what they said to be able to make my record.
I can tell you from a judicial perspective, not having the jury in the room at the time of that means that the Batson GR 37 issues, and I frequently don't have the jury, at least in both in my prior life and in this life. And when I was trying cases, I actually rarely had the jury in the room when we were exercising preempts, because that's actually not the most common way of doing things. It's sort of a Northwest way of doing things. But keeping track of that type of information from a judicial perspective is very important. And then, as the judge, being able to process on the Batson and GR 37 issues without having to remove the jury, have the argument, bring the jury back, it actually tends to speed things up. I know that we're running we're starting to run very short on time. Judge Scott, do we have any questions that haven't already been addressed in the queue that the rest of the panelists can join in on?
I believe they've all been addressed to the best of my quick ability.
Okay. And Roy, Alisa, Ann, Carl, anything else that you would like to add?
I guess I would say I feel like it's different. It's definitely different, but it's workable and it's a way to move things forward. I really feel like the only thing you lose, and I'm not sure it's a negative, is the 50 jurors in the room and kind of that group dynamic. But we also all know that people kind of get led along with the group. And so in a way, I think there's some things where you get better, truer information with the little panels where they don't get led along with the group. But that's really the only piece I see being lost here. And I'm not sure that's a plus or a minus.
We've just had two quick questions come in, one of which has been answered, but I'll answer it again. The video will be available soon, within the next several days. One participant asked about having pictures available for peremptory challenges and Batson objections. As Judge Williams said, that's going to be up to the trial judge, but many judges, and I'm one of them, have reservations about juror privacy invasion with photographs and the ability these days to do digital searching with photographs. So that'll be a subject of discussion at pretrial conferences, I'm sure. Judge Williams, further comments on that?
You know, I share your concerns. I think that they can be addressed, and those are conversations that can be had with the panels and with the jurors as they come in. And those are conversations that, but you know, especially in these times, digital things that are on the internet, of course, they're on the internet forever. Pictures, photographs, we have to be aware that there are both privacy issues, but there's also public access issues. And I know that in at least one of our trials in which this format was used, and used successfully, the judge had a very large panel. I think he had 23 jurors that they did the voir dire on, and it went very well. And he actually did take a picture. He actually filed that picture. All it had was the name of the, not the name of the juror, but the juror number. And so again, there's different approaches. All is well. Be calm.
Good words to end on. Thank you very much to all of our panelists and to our attendees. Thank you, and stay well.
Thanks, folks.
Thanks, everybody.
Thank you.